Please subscribe, like and share this video. Thank you for your support.
To U.S. Code Chapter 24, Congressional Accountability. To U.S. Code Subchapter A, General. To U.S. Code Paragraph 1301, Definitions. A. In general except as otherwise specifically provided in this chapter, as used in this chapter. 1. Board. The term board means the Board of Directors of the Office of Congressional Workplace Rights. 2. Chair. The term chair means the chair of the Board of Directors of the Office of Congressional Workplace Rights. 3. Covered employee. The term covered employee means any employee of A. the House of Representatives, B. the Senate, C. the Office of Congressional Accessibility Services, D. the Capitol Police, E. the Congressional Budget Office, F. the Office of the Architect of the Capitol, G. the Office of the Attending Physician, H. the Office of Congressional Workplace Rights, I. the Office of Technology Assessment, J. the Library of Congress, except for Section 1351 of this title, or K. the John C. Stennis Center for Public Service Training and Development. 4. Employee. The term employee includes an applicant for employment and a former employee. 5. Employee of the Office of the Architect of the Capitol. The term employee of the Office of the Architect of the Capitol includes any employee of the Office of the Architect of the Capitol or the Botanic Garden. 6. Employee of the Capitol Police. The term employee of the Capitol Police includes any member or officer of the Capitol Police. 7. Employee of the House of Representatives. The term employee of the House of Representatives includes an individual occupying a position the pay for which is disbursed by the Chief Administrative Officer of the House of Representatives, or another official designated by the House of Representatives, or any employment position in an entity that is paid with funds derived from the clerk hire allowance of the House of Representatives, but not any such individual employed by any entity listed in subparagraphs C through K of paragraph 3. 8. Employee of the Senate. The term employee of the Senate includes any employee whose pay is disbursed by the Secretary of the Senate, but not any such individual employed by any entity listed in subparagraphs C through K of paragraph 3. 9. Employee in office. The term employee in office means A. the personal office of a member of the House of Representatives or of a senator, B. a committee of the House of Representatives or the Senate or joint committee, C. any other office headed by a person with the final authority to appoint, hire, discharge, and set the terms, conditions, or privileges of the employment of an employee of the House of Representatives or the Senate, D. the Office of Congressional Accessibility Services, the United States Capitol Police, the Congressional Budget Office, the Office of the Architect of the Capitol, the Office of the Attending Physician, the Office of Congressional Workplace Rights, the Office of Technology Assessment, and the John C. Stennis Center for Public Service Training and Development, or E. the Library of Congress, except for Section 1351 of this title. 10. Executive Director. The term Executive Director means the Executive Director of the Office of Congressional Workplace Rights. 11. General Counsel. The term General Counsel means the General Counsel of the Office of Congressional Workplace Rights. 12. Office. The term office means the Office of Congressional Workplace Rights. B. Clarification of coverage of employees of certain commissions. 1. Coverage with respect to the United States Commission on International Religious Freedom, the China Review Commission, the Congressional Executive China Commission, and the Helsinki Commission. A. Any individual who is an employee of such commission shall be considered a covered employee for purposes of this chapter, and B. The commission shall be considered an employee in office for purposes of this chapter. 2. Authority to provide legal assistance and representation. A. Subject to paragraph 3, legal assistance and representation under this chapter, including assistance and representation with respect to the proposal or acceptance of the disposition of a claim under this chapter, shall be provided to the China Review Commission, the Congressional Executive China Commission, and the Helsinki Commission, I. by the Office of House Employment Counsel of the House of Representatives, in the case of assistance and representation in connection with a claim filed under Subchapter 4, including all subsequent proceedings under such subchapter in connection with the claim, at a time when the chair of the commission is a member of the House, and in the case of assistance and representation in connection with any subsequent claim under Subchapter 4 related to the initial claim where the subsequent claim involves the same parties, or 2. by the Office of Senate Chief Counsel for employment of the Senate, in the case of assistance and representation in connection with a claim filed under Subchapter 4, including all subsequent proceedings under such subchapter in connection with the claim, at a time when the chair of the commission is a senator, and in the case of assistance and representation in connection with any subsequent claim under Subchapter 4 related to the initial claim where the subsequent claim involves the same parties. B. Legal assistance and representation under this chapter, including assistance and representation with respect to the proposal or acceptance of the disposition of a claim under this chapter, shall be provided to the United States Commission on International Religious Freedom by the Office of Senate Chief Counsel for employment of the Senate, in the case of assistance and representation in connection with a claim filed under Subchapter 4, including all subsequent proceedings under such subchapter in connection with such claim. 3. Definitions in this subsection. A. The term, China Review Commission, means the United States China Economic and Security Review Commission established under Section 7002 of Title 22, as enacted into law by Section 1 of Public Law 106-398. B. The term, Congressional Executive China Commission, means the Congressional Executive Commission on the People's Republic of China established under Title 3 of the U.S.-China Relations Act of 2000, Public Law 106-286, 22 U.S.C. 6911 et seq. C. The term, Helsinki Commission, means the Commission on Security and Cooperation in Europe established under the Act entitled, An Act to Establish a Commission on Security and Cooperation in Europe, approved June 3, 1976, Public Law 94-304, 22 U.S.C. 3001 et seq. And D. The term, United States Commission on International Religious Freedom, means the commission established under Section 6431 of Title 22. 2 U.S. Code Paragraph 1302, Application of Laws. A. Laws made applicable. The following laws shall apply, as prescribed by this chapter, to the legislative branch of the federal government. 1. The Fair Labor Standards Act of 1938, 29 U.S.C. 201 et seq. 2. Title VII of the Civil Rights Act of 1964, 42 U.S.C. 2000 et seq. 3. The Americans with Disabilities Act of 1990, 42 U.S.C. 12101 et seq. 4. The Age Discrimination in Employment Act of 1967, 29 U.S.C. 621 et seq. 5. The Family and Medical Leave Act of 1993, 29 U.S.C. 2611 et seq. 6. The Occupational Safety and Health Act of 1970, 29 U.S.C. 651 et seq. 7. Chapter 71, relating to Federal Service Labor Management Relations of Title V. 8. The Employee Polygraph Protection Act of 1988, 29 U.S.C. 2001 et seq. 9. The Worker Adjustment and Retraining Notifications Act, 29 U.S.C. 2101 et seq. 10. The Rehabilitation Act of 1973, 29 U.S.C. 701 et seq. 11. Chapter 43, relating to Veterans' Employment and Re-employment of Title 38. 12. Section 9202 of Title 5. 1. B. Laws which may be made applicable. 1. In general, the Board shall review provisions of federal law, including regulations relating to a. The terms and conditions of employment, including hiring, promotion, demotion, termination, salary, wages, overtime compensation, benefits, work assignments or reassignments, grievance and disciplinary procedures, protection from discrimination in personnel actions, occupational health and safety, and family and medical and other leave of employees, and b. Access to public services and accommodations. 2. Board report beginning on December 31, 1996, and every 2 years thereafter, the Board shall report on a. Whether or to what degree the provisions described in paragraph 1 are applicable or inapplicable to the legislative branch, and b. With respect to provisions inapplicable to the legislative branch, whether such provisions should be made applicable to the legislative branch. The presiding officers of the House of Representatives and the Senate shall cause each such report to be printed in the Congressional Record, and each such report shall be referred to the committees of the House of Representatives and the Senate with jurisdiction. 3. Reports of congressional committees. Each report accompanying any bill or joint resolution relating to terms and conditions of employment or access to public services or accommodations reported by a committee of the House of Representatives or the Senate shall a. Describe the manner in which the provisions of the bill or joint resolution apply to the legislative branch, or b. In the case of a provision not applicable to the legislative branch, includes a statement of the reasons the provision does not apply. On the objection of any member, it shall not be in order for the Senate or the House of Representatives to consider any such bill or joint resolution if the report of the committee on such bill or joint resolution does not comply with the provisions of this paragraph. This paragraph may be waived in either house by majority vote of that house. C. Genetic Information Non-Discrimination Act of 2008. 1. In general, the provisions of this chapter that apply to a violation of Section 1311A1 of this title shall be considered to apply to a violation of Title II of the Genetic Information Non-Discrimination Act of 2008, 42 U.S.C. 2000 FF et seq. Consistent with Section 207C of that Act, 42 U.S.C. 2000 FF 6 C. 2. Construction. A. No limitation on other laws. Nothing in this section limits the provisions of this chapter that apply to a violation of a law described in subparagraph B. B. Other laws. A law described in this subparagraph is a law, even if not listed in subsection A or this subsection, that explicitly applies one or more provisions of this chapter to a violation.